offense of evading arrest or detention with a motor vehicle, third-degree felony is alleged in the indictment. However, the court does follow the recommendation of the state. The plea agreement assesses the 5 years deferred adjudicated probation, withholding finding of guilt, placing on defendant on 5 years deferred adjudicated probation under all the terms and conditions assessed by the court. In either cause number, Mr. Hall, in both cause numbers, I have from you waivers of your right to appeal. As I said earlier, your waivers of appeal, you and your attorney sign, waive and give up your right to appeal. And your waivers of appeal also in each cause number, waive and give up your right to file a motion for new trial. Do you understand those waivers, giving up your right to appeal, Mr. Hall, in both cases?
Yes, sir, I do, Your Honor.
Are you waiving your right to appeal, waiving your right to file a motion for new trial in each cause number, freely, intelligently, knowingly, and voluntarily, Mr. Hall?
Yes, sir, I have.
All right, the court receives and accepts the waivers of appeal, each cause number, orders and filed in the papers of the cause. And Mr. Hall, in both these cause numbers, with the, we've had a change, as have most courts and offices. Ordinarily, you would be standing here in front of the court with your attorney and state's counsel, and we would have gone through exactly what we went through, but then I would instruct you to report directly on down to the probation office to meet your supervising probation officer. However, we're not able to do that anymore. What I have to do, well, I can tell you this is a little bit different from most of the others. You need to report. They're going to give you a time at the probation office. So it's a term and condition of your probation that you report to the probation office today. When you are going to be able to report in person. When you report in person, you go into the probation department, tell them who you are. They'll have your plea papers. They'll have everything they need. And then you will be directed to your supervising probation officer. He or she will supervise you on probation for the driving while intoxicated. That's a specialized unit that supervises individuals for driving while intoxicated, third or more. That would be you in this case. So they'll direct you to your supervising probation officer for driving while intoxicated. You've got a lot of special conditions on your probation for driving while intoxicated. Your probation officer will explain them all to you. One of the standard ones is you have to have an interlock device on your vehicle where you blow into it and it has to show no alcohol before your vehicle will start. So you'll have to have installed on your vehicle normally an interlock device. Your probation officer, it'll be a condition of your probation that you keep it in good working order. They'll explain that all to you. They'll also have other special terms and conditions on your driving while intoxicated probation, and your specialized probation officer who only handles those type cases will go over all the terms and conditions with you. You will, in all likelihood, have a different probation officer, but it may be the same one. But you'll also have a probation officer you'll meet with today on your evading arrest or detention at the probation department. It is the order of the court, and it is a term and condition of your probation, your 8 years probation for driving while intoxicated in 2410641-20 that you report today in person to the probation department. It is also a condition of your deferred adjudicated probation in cause number 2410642-20 that you report in person to the probation officer today. Now, do you understand all this, Mr. Hall?
Yes, sir, I do.
This is obviously very important along with it because you're going to find out what all your terms or conditions are that apply as of today when you get down to the probation department, because your probation officers will go over all of them with you. Be sure you listen closely and understand all those terms and conditions. If you do not, be sure and ask them and they will make it clear to you. You do understand, and this is standard, you do understand it is now, and it'll be in the conditions signed by the court. It is the condition of your probation for driving while intoxicated, third or more, and a condition of your deferred adjudicated probation for evading arrest or detention that you report. It's the number one condition that you report personally to the probation officer today and meet personally with your probation officer so he or she can go over all your terms and conditions. Do you understand that?
Yes, I do.
The reason I just went over that twice is if you do not personally report by 5 o'clock today, they'll send me a violation report based on the fact you violated a term and condition of your probation by not reporting today to the probation department. That'll trigger no bond warrants for your arrest, and then the state can then use that to file motions to revoke your probation and a motion to adjudicate your deferred. So you understand the importance of being at probation today before 5 o'clock.
Yes, sir, I do.
And then they'll go over everything else with you at this time. You will have community service hours. We call them community service restitution hours. They'll be set in each case. Normally, driving while intoxicated would carry at least 300 hours of community restitution. Over here on the state jail, on the other third degree evading, probably be like 200 hours. You probably have a total of 500 hours between the two cases. Your probation officer may set them in a different amount or a different amount. That's really up to your probation officer, but you have to carry out those community service restitution hours. I can tell you on driving while intoxicated, you're going to have some rehabilitation you're going to be involved in for alcohol or substance abuse. Courses you go and attend as a term and condition of your probation. But they'll explain all that to you, Mr. Hall. The bottom line here is you do understand you've waived giving up your right to appeal in each case, and you understand you have to report to the probation officer today. Probation office, where you meet your probation officers today. If you do not report before 5, I'll get a violation report, no bond warrant go out for your arrest. And the state can use that to revoke your probation and also to adjudicate your deferral right off the bat. I know your attorney will go over all this and explain it to you, but I just want to be sure the record shows you do understand what I'm saying.
Yes, I do.
All right, Mr. Gilmore, you have anything else?
No, Your Honor, and I will make sure that that 1245 is filed today.
All right, thank you very much. Counsel, anything else from the defense?
Yes, Your Honor, just a couple of things. I just wanted to let the court know that Mr. Hall has had the portable interlock device, the at-home breathalyzer device for over a year since.
Okay. It's on, you're correct. It's on as a condition of bond.
Right. And
they'll continue that as well as you know, very well know. They'll continue. That's what I was talking about. That'll be continued as a condition of probation.
Yes, Your Honor. And the court granted Mr. Hall his occupational driver's license. And as a condition of that, the interlock device was already required. And I've instructed Mr. Hall on getting the interlock device as soon as he does have a working vehicle. But for right now, he's going to have his portable breathalyzer to satisfy the conditions of probation. We've also instructed Mr. Hall to report to the court for his fingerprinting on his judgment, along with reporting to probation today. The one question we had, Your Honor, we didn't know how the fines for the DWI conviction, the DPS fines, would reflect it on the judgment. Does the court have anything to do with that, or is that okay? There was no fines associated with this plea. I'm just
normally there's not there's nothing on the plea papers to indicate. I mean, the court did not assess the fine because actually on the driving while intoxicated third or more, there's a zero where it says dollars for a fine. There's a zero. The other one, the evading arrest for detention with a motor vehicle, it has nothing by fine. So apparently in the plea agreement, it was decided, it appears to be, that there would be no fine.
Yes, Your Honor. There was no fine according to the plea, but I was just wondering if the court knew anything about the DPS fines that might be imposed, from the transportation codes with a DWI conviction.
The court would not. I don't know whether or not, Mr. Chanis, can you hear?
I can, Your Honor, and we don't have that's DPS surcharges associated with DPS has to be taken up with them. It's not anything it's not anything the court can waive, and we can't waive it either.
Well, I've actually never, the best of my recollection, it's been a while, but normally that's a matter taken up by DPS, has to be squared away with DPS. It's not, I don't ever assess it or instruct in regard to it, but I tell you, if you ask, if Mr. Halsey, he can talk to his probation officer about it, they can probably tell him what he needs to do.
Yes, Your Honor. Thank you very much.
All right, Mr. Gilmore, you did not have anything else, is that correct?
Nothing else on this, Your Honor.
All right, and counsel, you do not have anything else then, so is that correct? Defense counsel has nothing else. I believe we're finished up.
That's right, Your Honor.
All
We
right,
don't-
now, remember, Mr. Hall, but I know I've said it 14 times. Today, you have to report personally to your probation department and see your probation officer before 5 o'clock today is the term and condition of your probation. I know you got it. 10-4. All right, we're in recess.
All right, thank you.
Forget about it.
Okay, go ahead.
Marcelo, I meant to ask you before I finished the play and I got off sidetracked.
Yes, Your Honor.
Does he have an assigned probation officer already? Because I didn't have a list of them or anything since he's supposed to report today.
Yes, Your Honor. He'll be assigned to Officer Laura Garcia, or DWI officer.
Okay, so, and they know he's coming today since that's a little different from how we've been doing it.
Yes, Your Honor.
Okay, thanks, Marcel. That's what I just did.
Yeah.
All right, we're on the record in calls number 2410571-20, State versus Brandon Earl Crocker on indictment charging evading arrest or detention with a motor vehicle. We're also on the record in calls number 2411950-19, State versus Brandon Crocker on indictment charging possession of a controlled substance. Mr. Chambliss is representing the state. Mr. Sawyer is representing the defendant, all present by Zoom. Court's probation officer is present by Zoom. It would appear to be there's a third case that's going to be 1245 in on the plea. The 1245 appears to be in cause number 2410119-20, a charge of forgery of a financial instrument. State jail felony is alleged in the indictment. Apparently in the plea agreement, that's to be taken into consideration by the court pursuant to Article 1245. So we will start over here with cause number 2410571-20. All the plea papers, they'll be going up on the screen. Mr. Crocker, I'm going to get you sworn in. They all appear to be signed by Mr. Heath Chamness, who's present on Zoom, by your attorney, Mr. Sawyer, who's present on Zoom. And there's a signature on the line above where it says defendant. Just looking at the plea agreement, when you look at it on that first page, State versus Brandon Crocker, there's going to be a signature down at the bottom of that page where you'll see, can you roll that up? Okay, do you see that signature, Mr. Crocker, there on the line above where it says defendant?
Yes, sir.
Okay, now that signature is going to be on all these plea documents. Is that your signature?
It is, Your Honor. The only thing that's missing was I had made a notation above where the jail time credit was wrote, and I don't see it on. It looks like it was cut off on the paper.
Are you talking about like on the agreed punishment recommendation?
Right underneath to run concurrent with cause. I had wrote.
Okay.
Jail
Mr.
time.
Sawyer, do you want to explain to your client what I told you?
Yes, ma'am. Is it possible to put us in a breakout room to protect attorney-client privilege?
Yeah.
Sure, that's fine.
Okay.
Actually, it's not going to let me. For some reason, it's not letting me.
I mean, the issue with it isn't, I mean, it's just, if I could ask Mr. Chamness, if I'm not on the right page with it, I mean, to me, it's just it's the mathematics of it that I wrote the jail time credit on there.
Mr. Sawyer, let me see if Mr. Chamness, where's the jail time credit?
Judge,
I'm sorry.
Your Honor, I can address it. The amount that he had wrote on there is not consistent with what the court was showing. I can't agree, and the court knows this, and Mr. Sawyer knows this. I can't agree to give him any more credit than what he has. If he bonds out on a case, he's not getting credit on that case until he's rearrested on that case. Same thing with if he's in custody somewhere else and a hold has not been placed on him, even though he may have cases in Smith County, until that hold is placed on him, he's not getting credit. My understanding is that the court staff has already calculated the amount of days credit. They're going to give him that amount today, and Mr. Sawyer can explain to him if he believes that that is an incorrect amount of time. He has the ability to calculate it, send whatever information he has that's supportive of that figure to the court. And if it's correct, the court can do a judgment non pro tunc to change the amount of credit. There's nothing for me to agree to. There's nothing for Mr. Sawyer to agree to today. The amount of time credit that he's entitled to is what he's entitled to. It's simply that simple.
Can I respond to you, Mr. Chamness?
Hang on, just to say, no, Mr. Crocker, you don't need to be talking right now. You need to let your lawyer address, Mr. Sawyer can address the court, or Mr.
Okay.
I can just tell you, as far as when the court pronounces these sentences, if the court follows the plea agreements, I don't have any reason to think I won't. When the court assesses the sentences in each cause number, what the court does is assess that sentence in each cause number with credit for time served. Then the sentence in each cause number would be ordered to run concurrent or at the same time. The court never states into the record the amount of days. The court simply assesses a sentence in the Texas Department of Corrections at blank years with credit for time served. And that credit for time served, that's figured by the jail staff here. And that's the credit for that's given. So I don't try to compute or figure up what it is. And I will not, all I'll do when I pronounce sentence, if these go through, I'll just assess the sentence under the plea agreement. I'll assess the number of years with credit for time served. That's what'll be in the record here.
Okay.
Okay, so let me see what we got here. The first case we're going to take up is cause number 2410571-20, State versus Brandon Crocker. Let me get you sworn in, Mr. Crocker. I got sidetracked a little bit. Just raise your right hand. Do you solemnly swear and affirm the testimony that you will give in each cause today will be the truth, the whole truth, and nothing but the truth, and all the plea documents signed and now signed and sworn to by you are being sworn to by you in each cause number freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, we'll go ahead and proceed unless something comes up that changes something. I'm going to go ahead and proceed with the papers I have in front of me. In cause number 2410571-20, that is an indictment charging the offense of evading arrest or detention with a motor vehicle. The evading arrest or detention with a motor vehicle, as alleged in the indictment, is a third-degree felony offense. Carries a sentencing range of not less than 2 nor more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. The indictment is getting ready to go back up on the screen so you can see this, Mr. Crocker. That's the evading arrest or detention with a motor vehicle alleged in the first paragraph, and that is a third-degree felony. I just gave you the full sentencing range, which is actually on the second plea document. However, there are 2 enhancement paragraphs, which are also indicated under the acknowledgement of admonishments. The first and second paragraphs allege that you have prior felony convictions. I'm going to read each one of those paragraphs to you. I'm going to ask you whether or not your plea is true or not true. If you enter a plea of true to the allegations in the second paragraph, it will increase your range of sentencing from a third-degree felony, not less than 2 nor more than 10, a fine of up to $10,000. But then that will be increased on the plea of true to the second paragraph. It will enhance your range of sentencing. And then the bottom line is going to be if you then plead true to the second and then the third paragraph, that's going to enhance your range of sentencing again. So if you plead of true to the second and the third paragraphs, which are allegations of prior felony convictions, they will take your third-degree sentencing range for the offense charge in the indictment 2 to 10, fine of up to $10,000. And it will, if you plead true to the allegations in the second and third paragraph, it will increase your full sentencing range on your plea to not less than 25 years, nor more than 99 years or life in the Texas Department of Corrections with a fine not to exceed $10,000. Now, of course, you have a plea agreement in this case, but do you understand what the full range of sentencing is? It's set out on the acknowledgement of admonishments that you and your attorney, you and Mr. Sawyer have signed. Do you understand that?
Yes, sir.
All right, so you've got your plea agreement. The first page is your plea agreement signed by you, signed by Mr. Sawyer. The plea agreement being that once the court takes your pleas, if you do plead true to the second and third paragraph of the indictment, your sentencing range will be enhanced up to 25, not less than 25 to more than 99 to life, fine may not exceed $10,000. But then you have a plea agreement for 35 years. Your 35-year plea agreement, 35 years in the Texas Department of Corrections Institutional Division, which is stated right there under where it says agreed punishment recommendation. Then out beside it, also part of your plea agreement is the 35, and the court's going to follow the plea agreement. So when the court follows the plea agreement, if you do plead guilty, and the court assesses 35 years in the Texas Department of Corrections Institutional Division, which, as I've already told you, will be assessed by the court with credit for time served. That 35-year sentence will be ordered to run as stated on the plea papers, concurrent with the sentence assessed by the court following the plea agreement over in cause number 241-1950-19, which is a sentence of 20 years in the Texas Department of Corrections Institutional Division. And under the plea papers in that cause number 241-1950-19, you'll see the 20 years assessed after I go through and you plead true to all enhancement paragraphs. I'll follow the plea agreement that says 20 years, and then the 20 years is stated it'll run concurrent with credit to the 35-year sentences. So the way your plea documents are laid out, if you do plead guilty, the court follows the plea agreements. The court will assess your sentence at 35 years for evading arrest or detention with a motor vehicle with credit for time served. Then the court will assess your sentence at 20 years in the Texas Department of Corrections Institutional Division for an enhanced possession of controlled substance, enhanced sentencing range at 20 years in order it to run with credit for time served concurrent with the 35-year sentence. So that's the way your plea agreements are set up as far as the sentences. Do you understand that?
Yes, sir.
All right, we're going to go on through because I need to take your pleas to the enhancement paragraphs over here. We're starting over here at cause number 2410571-20. That's the evading arrest or detention with a motor vehicle, as we've already talked about. That's a third-degree felony carrying a sentencing range of not less than 2 years. No more than 10 years, Texas Department of Corrections fine may be assessed of up to $10,000. However, you have second and third paragraphs. Those are enhancement paragraphs. They allege prior felony convictions. I'm going to read each one of them to you. If you do enter a plea of true to each one of these enhancement paragraphs, it is going to enhance your range of sentencing for this offense of evading arrest or detention up to a habitual range, not less than 25 years, nor more than 99 years or life in the Texas Department of Corrections, and a fine of up to $10,000. Do you understand that?
Yes, sir.
In cause number 2410571-20, charge evading arrest or detention with a motor vehicle, third-degree felony. The second paragraph is an enhancement paragraph. It alleges as follows. It is further presented that prior to the commission of the charged offense, hereinafter style the primary offense, it's alleged that on the 13th day of April 2007, in cause number 241-006406, in the 241st Judicial District Court of Smith County, Texas, it's alleged you were finally convicted of the felony offense of aggravated assault. Are those allegations true or not true?
True.
It's then alleged in the next enhancement paragraph, it is further presented that prior to the commission of the primary offense, that's the evading arrest or detention with a motor vehicle charged in this indictment, it's alleged in the last paragraph and presented that prior to the commission of the primary offense and after the conviction in cause number 2410064-06 was final. That's the conviction set out in the paragraph right before it. It's then alleged in this third paragraph that you committed the felony offense of aggravated assault and you were finally convicted on the 23rd day of October 2015 in cause number CR 150761-3 in the 173rd Judicial District Court of Henderson County, Texas. Are those allegations true or not true?
True.
Are you entering your pleas of true to the allegations in the enhancement paragraphs, the second paragraph and the third paragraph of this indictment freely, intelligently, knowingly, and voluntarily?
Yes.
Has anyone threatened you in any way, promised you anything, or coerced you in any way to enter your plea of true to the second paragraph of the indictment, the enhancement paragraph, or to the third paragraph of the indictment, the enhancement paragraph?
No.
All right, the court then does receive and accept your pleas of true to the allegations in the first enhancement paragraph alleging a prior felony conviction for the offense of aggravated assault. The court does receive and accept your plea of true to the allegations in the third paragraph alleging a prior felony conviction for aggravated assault as alleged in the indictment. Court finds each one of those pleas of true to the allegations in the second and third paragraphs, the enhancement paragraphs, was entered by you freely, intelligently, knowingly, and voluntarily. The court does receive and accept your pleas of true. The court does find as true the allegations in the second paragraph. The court does find as true the allegations in the third paragraph, which enhance your range of sentencing, as we've already talked about, up to not less than 25 years, nor more than 99 years of life in the Texas Department of Corrections Institutional Division, fine not to exceed $10,000. Do you understand all that, Mr. Crocker?
Yes, sir.
All right, moving to the plea papers now that we have in cause number 2410571-20. Mr. Chairman, let me just go over to cause number 2411950-19, and that's in regard to the enhancement paragraphs. They may have been done by the filing of a Brooks notice because the indictment charges possession of a controlled substance, intentionally and knowingly possess a controlled substance, namely methamphetamine, in an amount of less than a gram, which would be a state jail felony. Is there a Brooks notice filed over there, Mr. Chambliss? Because the indictment in 2411950-19, the indictment itself does not have enhancement paragraphs in it, which I would think it would be the same two that were in the first indictment, the way it usually is, but it has no enhancement paragraphs in it. So as that indictment stands, unless there's a Brooks notice, it would be a state jail felony range.
Your Honor, there does not appear to be a Brooks notice in the file. This was a case that was actually indicted prior to me coming into the court. The evading case was indicted by me, and the forgery case, which is being 1245 into the evading, could have also been enhanced, but it doesn't appear as if though. At this point, it was going to be ran concurrent. There doesn't appear to be a Brooks notice on file, which would have increased his punishment. So, assuming Mr. Sawyer is okay and Mr. Crocker is okay, we can change the plea papers to indicate that the punishment on this PCS will be 2 years in a state jail facility.
Well, why don't we do this? Why don't we do this, Mr. Chambliss? I've got a record of how far we've gotten, and we can pick back up where we are. But I think it would be better that we go ahead and let Mr. Sawyer get with Mr. Crocker over at the jail, and then you, when they come back to you, or you can go ahead and make the changes and initial them, Mr. Chambliss, and then Mr. Sawyer and Mr. Crocker could initial the changes if everyone is agreeable to it. I'd like to have those changes initialed on everything on the plea papers before I go through the pleas. And I'm talking about the plea papers for possession of controlled substance.
I don't have a problem with that.
I do want to know.
I can email them if you want to do it now.
Okay, well, what we'll do is Denise, my court coordinator, who's normally way ahead of the court, she says that she can email this set of plea papers because the changes appear to be obvious based on what Mr. Chambliss just said. The agreed punishment recommendation will have to be changed and initialed, and then under the acknowledgement of admonishments on the second page, it shows it enhanced up to a second degree. So I'm going to have her email the plea papers, and then we'll email them to you, Mr. Chambliss, and then can you send them on over to Mr. Sawyer? I don't know, how does Mr. Sawyer, I guess you can. Oh, wait a minute, Mr. Sawyer's at his office. We're all right.
Yeah, I'll take care of
Okay, I'm going to hand that set of plea papers to Denise, and she's going to get them emailed to y'all, initial them, send them back to Denise, and then we'll complete the plea.
Heath, can you run down and change them before I email them out?
Yes, I can come down and I'll make the change and initial it right now.
All right, Mr. Crocker, let me speak to the deputy in there with you.
Yes, ma'am.
Your Honor, if I may, Heath, would it be easier at my office? I can go to the courthouse and sign them with you if you need me to.
Do what?
I was saying if it'd be easier for everybody, if you just want me to run over to your office and sign them with you instead of emailing back and forth, I can do
Probably,
that.
probably would be, Mr. Sawyer, if you can do that.
I can, Your Honor. I'm right
Well,
across.
Okay.
hey, just go to the court's office because that's where I'm going to go to make the changes.
Just go to the 241st Court office. Denise will meet you there.
I'm in for what?
Hey, Banner,
I'm
Yes.
headed-
I am about to email some plea papers, I guess to Isaac's email.
Okay.
It's just going to be, well, it'll be the whole set. I will put a big sticky note where I need Mr. Crocker to initial, and then we can resume his plea.
Okay.
So
So
give
we
me about 10 minutes and I'll send it, I guess, to Isaac's email, if you can print them off and then scan them and send them back once he initials.
Okay.
All right?
All right. Thank you.
Whose? Not yours. It's on my screen, it's only got half of the flag and part of the back of the monitor. I think the chairs, no, the chairs were in here. Okay, then set down and wait. Sorry.
See, Boo, you have,
You just gotta go through the range of punishment on this one. The other one's done, and then you just go through your questions.
so, yeah, where did, yeah, where did the indictment get away to on this? All right, we are back on the record. This one in cause number 241-1950-19. We're still proceeding on the record in cause number 241-0571-20. Court had admonished the defendant, gone through the plea papers, enhanced range of sentencing and the plea agreement, the other plea papers in that cause number, charging, evading arrest, retention for the motor vehicle, which was enhanced to a first-degree felony on pleas of true to the enhancement paragraphs. Going over now to cause number 241-1950-19, which is an indictment charging possession of a controlled substance, namely methamphetamine, amount of less than a gram, which is a state jail felony offense as alleged in the indictment. I am not seeing the plea papers.
Do what?
Okay, I got a copy of it. Is that what we're dealing with? We're going off a copy? Yes, we are. I don't
Just
see-
the 3 pages.
I don't see the original.
They're right here.
Okay, you got them right there. Okay.
Yeah.
All right, coming up on the screen now is going to be in cause number 241-1950-19, State versus Brandon Crocker, possession of controlled substance less than a gram. The plea papers are up on the screen. The possession of, now the indictment charging possession of controlled substance less than a gram, state jail felony, carrying a sentencing range of not less than 180 days, no more than 2 years in a state jail facility. Fine may be assessed up to $10,000. Do you understand that, Mr. Crocker?
Yes, sir.
And we are back on Zoom with Mr. Crocker, his lawyer, Mr. Sawyer, State's Counsel, Mr. Chamness. I've got a set of plea documents over here on this possession of controlled substance less than a gram. They'll be going up, again, what you've already identified as your signatures on the line above where it says defendant, Mr. Crocker. The agreed punishment recommendation in this case now with the indictment charging possession of controlled substance less than a gram is if you do enter a plea of guilty to the indictment, in this case, state's recommending your sentence at 2 years in a state jail facility, that would be ordered to run concurrent or at the same time with the 35-year sentence assessed over in cause number 2410571-20 for evading arrest and detention in a motor vehicle enhanced up to a first degree. The 2 years, which would be assessed in the plea agreement in state jail felony, that of course would be assessed with credit for time served, and it would be ordered to run concurrent at the same time with the 35-year sentence assessed under the plea agreement in evading arrest or detention with a motor vehicle enhanced to a first degree felony. You understand all that, Mr. Crocker?
I do, Your Honor.
All right, in addition, I'm just going to go through and identify these plea documents in the possession of the state jail felony. We've got the plea agreement for 2 to do with credit to run C at the same time with a 35-year sentence over an offense charged in the other indictment. We've got an acknowledgement of admonishments that gives you the full range of sentencing. You're waiving your right to a trial by jury in this state jail felony. You're waiving confrontation with witnesses and agreeing to stipulate testimony. You've signed and sworn to a stipulation of evidence, written judicial admission, stipulating the facts, charging possession of a controlled substance, state jail felony, agreement to stipulate testimony, form for a waiver of appeal, request for waiver of the pre-sentence, which is approved by the court, trial court certification of your rights to appeal, and then trial court certification of your rights to appeal signed by you and signed by Mr. Sawyer. It has checked, it's a plea bargain case, you have no right of appeal, and also that the defendant's waived the right of appeal.
Yes,
And
Your
there's an
Honor.
advice of defendant's the defendant has received on his rights to appeal from his attorney. So all the plea documents over in 241-1950-19 charging possession of a controlled substance which is not enhanced. Yeah, your plea agreement 2 to do with credit to run concurrent with the other offense, and this has written on it under the agreed punishment recommendation, court-ordered drug treatment courses, i.e. Safe P. Mr. Chamness?
Your Honor, he had indicated, and I had talked with Mr. Sawyer, it's not safe P. He just wants the judgment to reflect that he would benefit from the utilization of the drug and alcohol treatment programs that are available at the institutional division. It's my understanding that unless the judgment has that on it, it will not allow him to be eligible for those programs. That's what that is.
All right, the judgment will have on it for Mr. Sawyer, counsel, and for the defendant, Mr. Crocker, the judgment will have on it that language in
Okay.
terms of suitable candidate for drug abuse treatment rehabilitation within the walls of the unit to which he's assigned. It will not say anything about safe P, obviously,
Okay.
because you'd be getting your drug treatment as provided by a unit in TDC, but it wouldn't be safe P. So I don't want to mark on the plea papers, I'm not going to, but as I'd understood, I mean, the court can't order safe P in a unit of the TDC, but the court will put in the judgment in this cause number 241-1950-19. This is a possession of controlled substance less than a gram. The court will make a finding in the judgment that the defendant would benefit from drug abuse treatment within the walls of the unit to which he's assigned, which is normally how it reads.
Okay.
Everyone says for that, state and defense.
State is.
Is that agreeable, Mr. Sawyer, Mr. Chamness?
Yes, Your Honor.
And is that agreeable with you, Mr. Crocker?
It is, Your Honor. Thank you.
All right, okay. And we've already gone through all the plea documents on the state jail. They've gone up, and you did sign and swear to all these plea documents in the possession of controlled substance state jail felony as shown by your signature at 241-1950-19. And you understand all of them, is that correct?
I do understand. It's correct. Yes, sir.
All right, now, Mr. Crocker, also, we've already been through in detail your plea in cause number 2410571-20, which sets out, and I've been over it more than once, that you've already, on your plea of guilty, the state's recommending 35 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit or to run concurrent or at the same time with the 2-year sentence in a state jail facility assessed in 241-1950-19. And then also the plea, for the plea papers on the evading arrest or detention, that's the one enhanced up at the first degree. It will have the same language in the judgment on that. On it, the court will find that you're to be admitted to within the unit to which you're assigned available court-ordered drug treatment courses, treatment within that unit, but it will not have anything about safety on it, same as the other one. Do you understand that, Mr. Crocker?
Yes, sir.
The court has already said, and the court is taking into consideration pursuant to Article 1245, a forgery charged under cause number 2410119-20, and any unfiled misdemeanors stemming from herein named offense. That's part of your plea agreement in the evading arrest or detention. The court will follow that. Mr. Chambliss will decline cause number 2410119-20, a forgery, because I am taking it into consideration in the assessment of 35-year sentence for the offense that you pled guilty to, evading arrest or detention with a motor vehicle enhanced to first-degree felony. Do you understand all that, Mr. Crocker?
Yes, sir. Does that include the misdemeanor evading arrest as well?
Your Honor, just for purposes of making sure it's on the record, the unfiled misdemeanor cases, I will put the DA control numbers and the type of case on the record. There's DA control number 20-01150, which is a misdemeanor evading case. And there is DA control number 19-05227, which is a misdemeanor PCS case. Those will also be declined.
All right, so Mr. Sawyer, your attorney, as well as you, Mr. Crocker, where it says this is in 2410571-20, this is the one evading arrest or detention. It hands to a first degree with a 35-year with credit. It's not what's on these plea papers right now is pursuant to Penal Code Order 1245. Court take into consideration a forgery under 2410119-20. And then where it says unfiled misdemeanors, the court is going to take into consideration, and I'll get it on paper from Mr. Chambliss, those two unfiled misdemeanors he just dictated into the record. They are being considered by the court pursuant to Penal Code Order 1245 in the assessment of the sentence of 35 years with credit for evading arrest or detention with a motor vehicle in 2410571-20. So Mr. Chambliss will dismiss those two unfiled misdemeanors he dictated into the record. Is that suitable with you, Mr. Sawyer?
Yes, Your Honor, that's my understanding. And,
Do you
and I,
understand, does that take care of your concern on that, Mr. Sawyer and Mr. Crocker?
Yes, sir. Yes, sir.
Yes.
Thank you.
I didn't have access to those numbers, Your Honor. Otherwise, I would have reflected them on the paperwork. So I apologize.
It's all right. Well, we've got obviously a transcript of all this that's covered, and I'll be sure all that's, Denise, and I'll be sure all that's set out in the judgment on this case. All right, now the court has gone through the plea documents, Mr. Crocker, and identified the plea documents that you've signed or signed and sworn to in your plea agreement for evading arrest or detention with a motor vehicle. And you understand the manner in which on your pleas of true to the second and third paragraph, which allege a prior felony conviction of aggravated assault, a prior felony conviction of aggravated assault. Your pleas of true to those have enhanced, increased your sentencing range up now to what is set out on the acknowledgement of admonishments, a range of not less than 25 years no more than 99 years to life, fine not to exceed $10,000. And you have a plea agreement I'm going to follow with the state for the court to assess under the judgment for evading arrest or detention with a motor vehicle and for enhanced to a first degree. The court's going to follow the plea agreement, assess that sentence at 35 years with credit to run concurrent over here with a 2-year sentence in a state jail. Each judgment will reflect you're to be admitted into drug abuse treatment counseling within the unit to which you're assigned at TDC. So I've gone through all the plea documents in both cases, identified both plea documents in each case. The court is now going to need to go through. Do you have any questions about anything we've gone over so far, Mr. Crocker?
No, sir.
All right, we're going to go on through now with the questions the court has for you in terms of your pleas to each one of these indictments. we're taking both these pleas at the same time. The sentences assessed under the plea agreements will be, which will be reflected in the judgments. There are to run concurrent at the same time with credit for time served. All the questions I'm getting ready to ask you right now, Mr. Crocker, for the record, all of these questions I'm getting ready to ask you, and your answers will apply to your pleas in both cases, since we're doing both pleas at the same time. Do you understand that?
Yes, sir.
Just to be sure for the record, you do understand all of the documents you've signed or signed and sworn to in each case. You understand your plea agreement in each case.
Yes,
Is
sir.
that correct? Do you have any questions for me about any of these plea documents we've been over in both cases?
No, sir.
All right. Do you still wish to go forward on your pleas of guilty to the indictments in both these cases without a jury?
Yes, sir.
All these questions now apply to the pleas in both cases. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
Yes, sir.
All right. I don't need to know what for. I don't need to know what institution if there was one. But are you being prescribed any medications right now? Not what they are, but are you taking any prescriptive medications like from a psychiatrist or a doctor?
Yes, sir.
Are you taking those medications pursuant to and following the prescriptions of the physician?
Yes, sir.
Do you understand everything you're doing in court today on both these cases?
Yes, sir.
Have you been over everything about the facts of both these cases
Yes, sir.
with your attorney, with your attorney, Mr. Sawyer, in both cases? Have you been over all the plea papers, the facts of both cases with your attorney?
Yes, sir.
Is he competent, Mr. Sawyer?
Yes, sir, he is.
Is there any evidence of incompetence,
No,
Mr. Chambliss?
No, Your Honor.
Court does know State's counsel signed his consent and approval of the waivers of trial by jury in each cause number. The court does approve the waivers of trial by jury and all the plea documents signed or signed and sworn to by the defendant, signed by the defendant's attorney in both cause numbers. All right, now, in regard to both of these indictments, you do understand all the allegations and the charge in the indictment for evading arrest or detention with a motor vehicle as alleged in the first paragraph, as well as the enhancement paragraphs alleged in the second and third paragraph. Is that correct?
That's correct. Yes, sir.
You understand how your sentence has been assessed from from a third degree felony 2 to 10 up to a sentence of not less than 25 years or more than 99 years of life in
Yes, sir.
the Department of Corrections. And you understand all your plea documents you've signed or signed and sworn to in 2410571-20 and all your plea documents you've signed or signed and sworn to in 241-1950-19.
Yes, sir.
Do you have any questions for me about anything, any matter in either case?
I do have one question. Is that okay to ask the question?
Well, of course, I don't know. I'm not your lawyer. I don't know what you're going to ask me.
Well, it is a legal question, and I want to ask this so I don't have any regrets when I'm sitting in prison 3, 4, 5 years from now.
Well, I think I don't know, not having any idea what it is, you probably need to ask your lawyer before you ask me, because I don't know what you're going to ask me.
It's about the sentencing. It's just about the sentencing of the 25 to 99. That's all it's about. It's just about a legal issue.
What is your concern about the 25? You understand that's the because of your 2 prior felonies in the indictment you pled true to.
Yes.
Evading arrest or detention, the third degree is enhanced up to a first degree. So your full range of sentencing is not less than 25, no more than 99 years or life, which of course is the full range of sentencing. Fine may be assessed up to 10,000. Do you have a question about that range of sentencing?
Yes, sir.
Okay, what is it? If your lawyer,
Okay.
if your lawyer doesn't mind, you can ask him. Do you have any problem with him asking me? I don't know what he's going to ask.
I don't have it.
Okay. So the Texas Penal Code section 1242D, if it's shown on the trial of a felony other than a state jail felony punishable under section 1235A with 2 prior felony convictions, it's 25 to 99 or life. The question I have is in 2011, 3 amendments were enacted to the evading arrest with a motor vehicle statute, both in the subsections B2A of the section. The latest of the 3 amendments elevated the punishment of evading to a third-degree felony, irrespective of any prior felony conviction. The appellate courts ruled that the ambiguous language still made it a third-degree felony, so they said the amendments could be harmonized. However, I haven't found where the Court of Appeals was confronted with or ruled on the application of the habitual sentences rule to the third-degree evading arrest statute. The reason why is the appeals courts have stated countless times that although a prior evading conviction is not required to charge third-degree evading with a vehicle, it is an essential element that proof of a prior evading.
Mr. Crocker, I apologize for interrupting you.
Oh, okay.
I think I know where you're going with this question.
Okay.
I believe I know the answer, but I cannot give you legal advice. So I'm going to have to stop right here.
Oh, okay.
If you want to get an answer on that, it will have to come from Mr. Sawyer, your attorney, because I
Okay.
can't try to answer that type legal question, because then I would be giving you legal advice, which I cannot do.
Okay.
So I'll
Okay.
give you time. I'll give you time if you want to talk to Mr. Sawyer. I don't know where that's questions is going, but right now, what I would have to do is recess the hearing and give you time to talk to Mr. Sawyer and satisfy yourself about this question. Then we'll pick back up with the plea at the time I can give you, after you've had a chance to confer with Mr. Sawyer. And I want to be sure he has a chance to confer with you on your question. You have anything to say, Mr. Chambers?
Your Honor, this is the third time we've reconvened. The offer that's been made started off as one thing. As part of the plea agreement, I agreed not to put a deadly weapon in the thing.
I'll proceed. I'll
I
proceed.
then lowered it. If he's wanting to talk about figuring out ways to appeal this case and et
No,
cetera,
no.
we can just withdraw the plea right now and he can sit in jail and we'll try it and I'll get up and ask the jury to assess a life sentence on a
No,
halftime offense.
no,
I'm
not-
not messing with him anymore.
That's not what I'm trying to do. That's not at all. I
Listen
want
to
the
the court.
35.
Listen to the court. I'm not going to have the record standing as it is right now. Okay? I don't have any option with this question being asked on the record to the court. I don't know where the question was going, but I'm going to recess the hearing, and it may be the third time. Whether or not Mr. Chamness goes forward with the plea is not complete. I've not followed the plea agreements and assessed the sentence. I intended to, but I'm not going to go forward at this time until Mr. Cronker talks to Mr. Sawyer and satisfies whatever question he has. And after he's had an opportunity to confer with Mr. Sawyer, his attorney, then we'll come back on at probably going to be a later date. We'll come back on when I can get it scheduled.
Your Honor,
I'm not going for, listen to me. I'm not going forward with it, Mr. Crocker, based on what you started to ask on the record. I'm just not going to do it. I'm not comfortable with it. I'm not comfortable with the way the record is. Because if you've got a question in your mind, you need an opportunity to talk to your attorney, Mr. Sawyer.
But I don't want to lose my opportunity to get the 35-year deal. It's just if it was a state jail felony or not. That's the only question I had, Your Honor, with all due respect.
The problem is you're going to need to talk to Mr. Sawyer, your attorney, for your legal advice. The court can't give you legal advice. I've gone through thousands of these pleas, and I have a set of questions I go through. I can't get off into giving you advice. I wouldn't be able to ask the question, but the fact that you've posted on the record creates a concern for me.
Can I withdraw it, please?
No, you cannot withdraw it because it could come up later. And I don't want to have that part of the record. So you're going to have to talk to Mr. Sawyer, get this ironed out. And once I'm comfortable that you had an opportunity to talk to Mr. Sawyer and he has advised you, then if Mr. Chamness still wants to go forward with the plea, it's fine. The court will still accept the plea agreement unless it's withdrawn by Mr. Chamness. But I'm not going forward with this plea with that type potential question on the record, which could be raised at some later time. And so you've got to have an opportunity to talk to Mr. Sawyer. We're going to be in recess. Let me see when we can reset it forward. Just stand by a minute. in both these calls numbers, 2410571-20. State versus Brandon Earl Crocker, evading arrest or detention with a motor vehicle enhanced to a first-degree felony. Also in 241-1950-19, indictment charge of possession of controlled substance, state jail felony. Still with defense counsel, defendant, Mr. Chambliss, representing the state, all present. Still all present by Zoom. The court is going to reset the plea, and that we obviously have a lot of other pleas that are already scheduled. The court is going to reset the plea by Zoom for Tuesday, August the 25th. At what time, Denise?
3 o'clock.
Tuesday, August the 25th at 3 o'clock. At that time, the court will go back on the record by Zoom and determine whether or not we're going to go forward or whether or not the plea agreement's still on the table. I'm sure I'll know before then, as will Mr. Sawyer, whether or not it's withdrawn. If it's not withdrawn, then the court will go forward with the plea on Tuesday, August the 25th at 3 o'clock. Do you have that, Mr. Sawyer? Did I lose you?
I'm here. I'm sorry, Your Honor. I was
Okay,
checking.
Mr. Sawyer, do you have it Tuesday, August 25th at 3 o'clock?
Yes, sir, I do, Judge.
All right, have you got it, Mr. Chambliss, Tuesday, August the 25th at 3 o'clock?
I'll be here, Your Honor.
All right, the court is recessing the pleas in both these cases. If the offers are still on the table, the court will go forward with the pleas, conclude them on Tuesday, August the 25th at 3 o'clock. And Mr. Sawyer, you need to get with Mr. Crocker to meet personally with him. I'm not telling you what to do. You know this. You need to get with him. He's going to ask you his question. I've got to be sure that his pleas are free and done freely, intelligently, knowingly, and voluntarily in each case. I can't have some legal issue floating around out there he wants an answer to that the court can't advise him on. So we're in recess until defendants continued in custody of the sheriff until Tuesday, August 25th at 3 o'clock, when we would be reconvened by Zoom for the pleas. We're in recess.
Your Honor, before we adjourn, may I just, since normally we'd be in person, I could ask Brandon, could I just ask him to call me?
Sure.
Thank you, Your Honor.
Yeah.
Go ahead. You can ask him to call you. I just wouldn't be any legal advice. He
Yes, sir.
wants you to call him. Mr. Crocker, Mr. Sawyer wants you to call him.
Thank you. I did not mean to stir up any recesses like this. Was not my intention.
We're in recess. Be back in session Tuesday, August 25th at 3 o'clock if the plea agreements are still on the table. We're in recess.